The Presidential Election Petition Tribunal yesterday validated the election of Bola Tinubu as the President of Nigeria, satisfied that he was duly elected by a majority of the lawful votes and that the petitions against him lacked merit and were liable to be dismissed. The court further held that the candidate of the People's Democratic Party, PDP, Atiku Abubakar, and his Labour Party counterpart, Peter Obi, failed to prove allegations of substantial non-compliance, amongst others, against Tinubu during the February 25 presidential election. The ruling, which lasted over 12 hours and delivered by Justice Haruna Samani, however, addressed 5 fundamental issues in the various petitions which have become the takeaways from the ruling. They are that Abuja has effectively become Nigeria's 37th state and did not require the hitherto constitutional 25% votes in a presidential run, that INEC was not under any compulsion to use beavers, that the electronic transmission of results was equally at the discretion of INEC, that Tinubu's $460,000 forfeiture was not criminal in any way, and lastly, that the candidacy of the president was fit and proper. According to the tribunal, which cleared the air on the controversial 25% of votes accruable to a winner in Abuja, the Federal Capital Territory, it said was not a requirement for the declaration of results, adding also that the Independent National Electoral Commission, INEC, was not under any legal compulsion to transmit results electronically. President Bola Tinubu yesterday responded to the news of his electoral victory affirmed by the Presidential Election Petition Court from India, where he was participating in the G20 summit, and saluted the diligence, undaunted thoroughness and professionalism of the 5-member bench led by Justice Haruna Samani in interpreting the law. He, however, urged his co-contestants, Atiku Abubakar of the People's Democratic Party, PDP, and Peter Obi of the Labour Party, as well as their supporters, to give his government the requisite backing in collective interest.
It's been a very, very strong and emotional journey for all of us, struggling for democracy, truth, and justice for all. Today, we give kudos to the judiciary for their indefeasible commitment to rule of law and to humanity. Thank God Almighty for guiding us this far and protecting us. With your support, joys, and adulation, the theme for Nigeria is for us to pull Nigeria up and be proud of a country. That's the only country that we have. 1 out of 4 black race is in Nigeria. Well-educated, dynamic, collaborative, and forward-looking people. Hard-working, no doubt. We have no reasons to be poor. Don't look back. Look forward. Let's pull the country forward. And with your help, my friend, my colleagues, and all of you, I promise to do more.
The president there saying, don't look back, look forward, promising to do more, and obviously many things to discuss this morning, Rufai.
Okay, so one, let me start from the congratulations. There have been congratulations. Members of the APC have applauded it, and also there have been rebuke. Labour Party said they rejected the result of this judgment while the judgment was even being read. The PDP said they were going to go to the Supreme Court. And there are many areas that we need to tackle for the Supreme Court. And take, for instance, the issue of the 25%. I think there still needs to be more clarity. So I was saying now that Abuja is a 37th, state, and what is even the intention and the thoughts of the framers of the Constitution in the first place? Another question is, why did INEC take us through this merry-go-round as Nigerians constantly, with many copious evidence, saying that they were going to have an electronic process, only for electronic process not to hold, because there's been another report that 3 days to the elections, they said that they were just going to take a picture of the result and put it on the IRF portal. Why did INEC come on this show to fight even against the National Assembly when they said they were not going to be part of electronic transmission? Because that was what made a lot of people say they want to get interested in the process again. And when you look at it, the process of our elections that have constantly suffered massive levels of voter apathy, the cure will have been the electronic transmission of results. So when the court also made the argument that INEC isn't mandatorily bound to transmit electoral results to the IRF, let's take a look at Section 64, Section 4B of the Electoral Act. That is, a collation officer or returning officer at an election shall collate and announce the result of an election, subject to his or her verification and confirmation that the votes stated on the collated result are correct and consistent with the vote or result recorded and transmitted directly from polling units under Section 6, Section 4 of this Act. So there still needs to be more clarity. So why did INEC say we're going to do this? And because there was also another report where there were doubts about using the electronic transmission, and INEC came out to reiterate in another letter and piece about that. I think that letter was authored by Festus Okoye Esquire on the 11th of November 2022, where there was an alleged plot to abandon the transmission of polling unit result to IRF portal. And in the letter, the INEC said attention has been drawn to section of the media alleging that our plans to rig 2023 election, abandoning direct real-time blah 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 transmission to INEC portal. And he said the IRF is one of the innovations introduced by the Commission to ensure the integrity and credibility of results in Nigeria. It's therefore inconceivable that the Commission will turn around and undermine its own innovations. So, all of this conundrum, INEC said it was going to do something to bring back. Because if we're saying that INEC can use any process to collate reports, and if, like the court said, it means that we've gone back to the EU days of elections, where it could be a do or die at the polling unit, and the truth is that there's a big problem of the burden of proof. And don't get me wrong, when the judges talked about it, the burden of proof is always hard. And the judges did eviscerate the petitioners on the burden of proof and also vis-a-vis the Evidence Act, because it's quite difficult to prove. Take, for instance, I am not sure, and correct me if I'm wrong, that any political party in Nigeria has polling unit by polling unit EC8A forms for over 50,000 polling units. Where are you going to get? Your strong room has to be very strong under election conditions where your polling agents might not even take a proper picture of it and things like that. It's always difficult. And a lot of people felt that the IRF was going to be the basis to be able to actually authenticate the report and look at this result. And there was a glitch in the process also, proving that it's quite very difficult. So, as always, in every case, the burden of proof as regards our electoral jurisprudence and the idea of, that there's a presumption of regularity on INEC is also a very big challenge. So, proving is very, very difficult in the court process. And that's why, to be able to deepen our jurisprudence, we would like to see, some parties have said they're going to go to court, congrats to the winner. We would like to see how all of this pans out in the Supreme Court, so we can learn more and have this argument. But, a couple of things, Nigerians, there needs to be a need to go back to the National Assembly as regards fine-tuning electoral laws. It's an ongoing process.
Okay. Yesterday, there are lordships, 5 of them, sitting in the Presidential Election Petition Tribunal, gave their judgment. It's not the end of the road. Within the purview of Section 285 of the Constitution, the matter, can still go to the Supreme Court. And already, both the legal advisor of the Labour Party and lead counsel for the Atiku team, Chris Uche SAN, have both indicated that they will be proceeding to the Supreme Court. When they file, their appeal at the Supreme Court, we still have some 60 days within which the Supreme Court will determine the matter. But from what transpired yesterday, one of the longest judgments ever delivered in the history, of the Nigerian courts, over 12 hours. Their lordship started at 9:40. More than 12 hours later, they were still at it. At the end of which, they ruled that President Bola Ahmed Tinubu was duly elected and he was duly returned as president of Nigeria, which is a major victory for both the APC and President Bola Ahmed Tinubu. So congratulations are in order, to the extent that we have seen APC members dancing. Even there is a video of the president himself dancing and singing along with others in faraway New Delhi, India. Now, so double congratulations for him. On the day the tribunal ruled in his favor was also the day some investors in India pledged a total of about $14 billion that they are proposing to invest in Nigeria. Now, what are the issues addressed by their lordships in that ruling yesterday? One, they ruled that the allegation of double nomination of Vice President Shettima as a candidate then was a pre-election matter which should have been taken up then, and beyond that, it was an internal party affair. Therefore, they dismissed that. Two, they said that the query by the APC about Mr. Peter Obi's membership of the Labour Party is also an internal matter of the party, which is non-justiciable within the framework of the law. Number three, they ruled on the alleged, allegation that Tinubu is not qualified within the purview of Section 134 of the Constitution. They ruled that he is in fact qualified, in that election. The allegation that he paid $460,000 to a district court in the United States, and that on the basis of that he should have been disqualified. The court ruled that there was no criminal conviction. This was not a case of criminal conviction, it was a case of civil forfeiture. Number five, they further ruled that on the question of the status of Abuja, which has been very contentious, people have been throwing that up and down, Section 134 sub 4B of the 1999 Constitution. They ruled that in fact that section is to be read conjunctively, that Abuja does not enjoy any special status. Six, they ruled that the Labour Party could not show how many votes, additional votes that it claimed that it had. Seven, they said in the 18,088 polling units that the Labour Party claimed, overvoting took place or there were manipulations. They ruled that Labour Party could not in fact provide evidence of those polling units or the quantum of votes from those polling units. Number eight, on the allegation of dual citizenship on the part of candidate of the APC, Bola Ahmed Tinubu, they also ruled that in fact the PDP and Atiku Abubakar, who brought that matter, was trying to smuggle in evidence that was not originally filed, and that the PDP and Atiku Abubakar were trying to be clever by half by trying to smuggle that in. So on the whole, their lordships ruled that the petition by the three parties, the APM, the Labour Party, the PDP, lacked merit. And on the basis of that, those petitions were dismissed. And that, they could not prove their case. They even, in fact, expunged from the record 11 of the 13 witnesses that the Labour Party brought forward. And similarly, parts of the, records by the People's Democratic Party were also expunged from the record of court, which will look like a very strong indictment of the counsel of those two parties, and also counsel for the APM. So this was the ruling. Now, I've had many people expressing opinions saying, well, this does not reflect the will of the people and all of that. But what is interesting is that in the last few days, lawyers have been quoting ad nauseum, the statement of Nikki Toby, JSC, as it then was, in Abubakar versus Yaradua, 2008, where he made a point that, look, the courts don't rely on public opinion. It's and the courts will not go on a voyage of discovery to go and look for evidence in Wuse Market, in Jos Central Market, or in Uyigbo Market. The court is committed to arid legalism. In other words, the court is faithful only to the law and the evidence that is provided before it. It will not go on a frolic of its own to go and look for evidence in the marketplace. And I think it's instructive that Nikki Toby's statements in that particular case, is being cited as relevant, and that, look, the judiciary has a job to do its duty. And you could see yesterday their lordships insisting on doing their work. And in fact, to the extent that they, resisted any form of interference. It's also interesting that George Oguntade JSC, as he then was, his statement in Amechi versus INEC and others, also a 2008 case, I think, has also been quoted. In that case, Justice Oguntade said, his duty was to do justice, even if the heavens fall. And that in any case, even when justice has been done, the following morning, the heavens will still be in place by George Oguntade JSC, in that particular case, Amechi versus INEC and others. So there are many people who feel that justice has not been done. Well, the court does not rule on the basis of feelings or sentiments. That's meant for, the public. But the provision here is that the matter can still go to the Supreme Court. Now, there were some interesting moments at the court yesterday in the course of the proceedings. One, their lordships, reprimanding Charles Edosanwa, SAN, who had interfered with the delivery of the judgment, trying to hurry up the judges. They had to ask him not to teach them how to deliver judgments. And, he got away lightly. Otherwise he could have been charged for contempt, trying to interfere the delivery. Now, second, Justice Stephen Nada, when he was making his own submissions, he went after lead counsel to the Atiku team, Chris Uche SAN, reminding him of a book that he had endorsed and the position in that book, and how in bringing the Atiku PDP matter to court, he was contradicting himself. I thought that was a bit embarrassing. So many lawyers, on WhatsApp were laughing at that. And then, of course, the third point was that all the people who have been saying all eyes on the judiciary, all eyes on the judiciary, when they got to the tribunal yesterday, maybe, well, it's because of the nature of the work, it's because, the AC was blowing cold very well. Half of the court, most of the counsel fell asleep. And, social media yesterday was agog with all kinds of portraiture of counsel opening their mouths and snoring and enjoying deep slumber, a parade of somnambulism, in the courtroom, including even journalists who took time out.
Don't go there. Dr. Don't go there.
No, including...
Dog doesn't eat dog.
No.
I won't take this from you, Dr. Abati.
Just wait now. Didn't journalists also sleep?
Don't go there.
In front of the judiciary, they closed their eyes.
Resting their eyes.
They were resting their eyes. Journalists don't sleep, Dr. Abati. I will not go there.
It's all right. It's all right. It is social media. They say photos don't tell lies. But in any case, it was a very detailed, very comprehensive ruling, almost unassailable, if you ask me. But in any case, the petitioners have said when they get the certified true copy of the ruling, they would proceed to the Supreme Court that will have a final say. Well, it is for the counsel, affected counsel, to identify the issues that they would take up. But in any case, there were so many dignitaries in court, the APC chairman, the Labour Party chairman, some governors were there, governor of Ekiti, former governor of Yobe, governor of Kogi State. It was well attended. Some actors were even there. I thought I saw Zakoji there. I saw Yule Doche there. And then outside the court, you had some characters staging a drama of their own. Quite a special moment in the trajectory of the 2023 general elections. But as I said, the parties involved say they still want to go to the Supreme Court. And it will be interesting to see what the Supreme Court will rule on the basis of some of the issues that they may want to further contend.
Well, it had been described even prior to the ruling yesterday as an epochal moment for Nigeria and Nigerians, and that's what we witnessed with the judgment delivery of over 13 hours, a number of people glued to their TV screens or their devices, depending on what platform they were watching, and almost every word delivered by each of the justices who had read the judgment yesterday being eaten by not just journalists or people who were going to report, but Nigerians who had taken a keen interest in this particular case. What had been suspected was that there might be some upheavals, some surprises here and there. However, the verdict is that there were not many major surprises, especially depending on what part of the divide you stand. But a few things and a few questions that rose following yesterday's judgment by the judges is this. Number one, is Abuja now seen as a 37th state? As I had mentioned earlier on, this brought up a number of questions, and perhaps if the case is taken to the Supreme Court as asserted by the petitioners, then it would be something curious to delve into a bit deeper, especially what the implications would be outside of election matters. So then the question would rise as to Abuja, the FCT now being regarded as equal with other 36 states of the Federation, would there be an implication for how it is run, governance in Abuja, other aspects like that? So those are some of the questions and debates that have gone on since yesterday. Second is the issue around the electronic transmission of results, especially BVAS, and that's being not being admitted in terms of saying it's discretionary on the part of INEC. If this were discretionary, then 105 billion that was allocated or spent on acquiring BVAS would then begin to question as to how important in putting or investing such an amount of money. Don't forget that following the Electoral Act, one of the things that a number of people have said, and even INEC themselves had reiterated, was that BVAS was the game changer. This was going to make the big difference between this particular election and previous elections that had been held or curated in Nigeria in the past. However, the court rules following their interpretation of the Constitution and the Act that BVAS is not compulsory but at the discretion of INEC, then it changes the game. And then perhaps it would even mean that, and has been already said by a number of lawyers, analysts, that there are a few parts of that act that still need to be revisited, and there are a few broad or perhaps not very specific items in that particular act. And so it's still a work in progress and it might still be revisited. Again, going to some of the reactions by Nigerians, a few people who felt disgruntled, even the petitioners who didn't feel like the judgment by the courts reflected the will of Nigerians or was in this case fair to their defense, then it would mean as well that we need to look at the issue of judgments, the timeline of judgments given, especially in an election matter. This is an opportunity for us to raise that case again for judgments, especially tribunals, election tribunals, wrapping up or rounding off before the swearing in of the president, for instance. Because yesterday, as was said, the president was going on a matter of governance whilst his case was being decided here in Nigeria. And it's quite difficult, even with the courts, to begin to overturn or to overrule the election of a president who has spent 100 days in office, who has consolidated in many parts himself as president, who now, at least for the last part, is responsible for the remuneration, at least the office of the executive, of the judiciary. It's quite difficult in that instance to begin to upturn or cause an upheaval in the nation or perhaps in governance in the nation. It's quite difficult. And so this presents an opportunity to revisit that again, that perhaps the 180 days allocated for the deciding of presidential election petition matters is not adequate. It's not reflective. It doesn't work. And again, just to mention that the burden of proof is on the petitioners. And oftentimes, no matter how much we feel, oh, this ought to be this way, it has to be this, we can see it's glaring, we all saw what's happened. At the end of the day, the justices have to go by the Constitution, by evidence is presented before it. And so it might not favor popular opinion, but the lengthy judgment given by the justices yesterday, especially with each item taken one after the other and explained, demonstrates that to a very large extent, it is according to what the lawyers have brought. Again, if it goes on to the Supreme Court, it would be interesting to see, because they're not going to present any new evidences. No new evidence will be admitted. It will just be a review, a judicial review of the judgments given yesterday by the Court of Appeal. A number of options now available to the petitioners. Some, I don't know if, the PDP camp have categorically said that they would go on to the Supreme Court. The Labour Party, on the other hand, has only said that they reject the judgment, but they would explore options. They haven't said exactly if they will pursue this up onto the Supreme Court based on the judgment that was given yesterday. The drama still unfolds, and we'll continue to bring updates. In the course of today's show, we're going to be analyzing even more yesterday's judgment.